Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to go back to Smith Wesson versus Mexico, a ruling that really didn't shock any of us, but we are going to go back to that little nugget where Justice Kagan, writing for the 9-0 majority, was quoted as saying, AR-15 rifles, AK-47 rifles, and 50 caliber sniper rifles are both widely legal and bought by many ordinary consumers. And of course, that had many content creators sitting there going, oh, look at that, look at that, look at that. Well, I tell you what, we weren't alone, because those that are actually down in the trenches fighting right now, some of the plaintiffs' attorneys, they caught it as well. And they filed a lot of what we like to call memorandums of supplemental authorities, which is a case that is currently being litigated. You file something late, you ask permission from the court, and you say, hey, you might want to consider this as well. Well, now those that are supporting civilian disarmament are actually beginning to file their responses, so we're going to need to go through that so you can see what the playbook looks like. So today, let's spend a few minutes and let's talk about when the lawyers start telling you what judges really said. Okay, America, we're sort of talking about Smith Wesson versus Mexico, but we're actually going to be talking about two other cases that are currently undergoing litigation. Now, we remember in the opinion that we've already been talking about, Justice Kagan gave us this beautiful little quote right here. Well, as I mentioned, some of the plaintiffs' attorneys around the country, they caught it as well, and they immediately filed supplemental memorandums of authority. The two cases that we're going to be talking about today are National Association for Gun Rights versus Lamont, which is a challenge to Connecticut's assault weapon ban and high-capacity magazine ban. And then we're also going to be talking about Rocky Mountain Gun Owners versus Town of Superior, which is a challenge to the Town of Superior's assault weapon ban and high-capacity magazine ban. I guess they don't have state preemption laws in the state of Colorado. Now, why would this information that these firearms are in regular circulation, owned by millions and millions of lawful, responsible Americans, be important? Well, it's because, as you know, everything comes down to one thing and one thing only: it's in common use. That's right, the common use test. And it's not in common use for self-defense, it's in common use for any lawful purpose. And even though Heller completely spelled that out, and many of these district courts have not gotten the memo. So the case law is very, very clear, America. If an arm is in common use for any lawful purpose, it may not be banned. The equation is really that simple. But this does give me an opportunity to do some deep geek out and teach you yet another legal term, which is the term dicta, okay? Because you might as well learn this, because this is going to be part of the response. What exactly is dicta? Well, according to Black's Law Dictionary, in law, dicta refers to statements made by a judge in a legal opinion that are not essential to the decision of the case. While not legally binding, like the ratio decidendi, reason for the decision, dicta can still be influential and persuasive in future legal arguments. So, in a nutshell, if the language is about something that is only tangentially related to the case, okay, it does not go to the actual ruling, well, then what some attorneys, those who don't like the statements, will argue is that it has no probative value, it has no authoritative value. And sometimes that is the case, and sometimes it's not. And really, the beauty is in the eye of the beholder. Now, as you may recall, the actual issue in Smith Wesson versus Mexico was the application of the Protection of Lawful Commerce in Arms Act, and whether or not there was really a true workaround to that statute. And so the way the state of Connecticut has responded, because what happened here is plaintiff's counsel, those suing on behalf of the lawful, responsible gun-owning residents of the state of Connecticut, filed a memorandum, said, hey, Judge, you better take a look at this, okay? The state of Connecticut has responded as follows. Smith Wesson Brands does not address the Second Amendment and has no bearing on this court's analysis. If a statement did not address the point now at issue, and the issue was not fully debated, it is dicta, which the court is not bound to follow. And again, after pointing out that the purpose of the suit was the applicability of the PLCAA, which it was, the state of Connecticut also states, this has nothing to do with the PLCAA. The question here is whether Connecticut may prohibit assault weapons and large capacity magazines in part because they are dangerous and unusual weapons unprotected by the Second Amendment. As defendant already demonstrated, plaintiffs cannot show Such weapons are protected by the Second Amendment. Nothing in the Smith Wesson brands Inc. changes that. Now, things even got a little saltier out there in Colorado, where the state of Colorado basically has filed arguments that says, hey, number one, the court shouldn't even consider this. And number two, even if you do, it really doesn't mean what it says. And again, the state of Colorado, they got a little, snooty about the whole deal, because they write this: even if plaintiffs' new arguments were properly before the court, it is entirely without merit. But then, as you can see, they got this little footnote, okay? And then the geeks like me, we go down and read these footnotes also, and this is what we find out. Given the plaintiff's inclusion of improper legal argument in their notice, defendants respond briefly here. Should the court strike or otherwise disregard plaintiff's notice, this responsive argument can be disregarded. Well, there's one of the biggest no in the history of legal briefing. Okay, but now, to just throw a little extra salt on everything, at the end of their memorandum, they point out that, hey, listen, we should totally disregard Smith & Wesson v. Mexico, but we should take note of the fact that Snope and the petition on certiorari on Snope was denied, because the state of Colorado pleads, at bottom, plaintiff's position is that the Supreme Court denied certiorari in a Second Amendment challenge to a law restricting assault weapons on Monday, only to dispositively and unanimously decide that such laws are unconstitutional on Thursday in an opinion concerning an entirely different subject. That is absurd. Oh, and then they drop another little footnote there, and then a little extra salt comes with the fact that they also point out that Hansen versus District of Columbia was also summarily denied by the United States Supreme Court. So, I know a lot of you sat there and were like, well, I don't know if that's really as valuable as it was. It may be dicta, and dicta is in the eyes of the beholder. Okay. Let us also remember that Justice Sotomayor has made a similar statement when it comes to AR-15 rifles. So that is the playbook, and I'm certain that there were many other plaintiffs' counsel out there that also probably filed similar memorandums of supplemental authority, and they will be treated in the same way by those states that are advancing civilian disarmament. And ultimately, what it really comes down to is a bunch of lawyers saying, hey, let me just tell you what the judge really said, or let me just tell you what the judge really meant. Okay, the case is once again NAGR versus Lamont, that's out of Connecticut, and Rocky Mountain Gun Owners v. Town of Superior, that's out of Colorado. Linking them both up down below. You don't have to take our word for it. You can geek out on it for yourself. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, cool. Tell us all about it by clicking on that link right there. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.